Hello, I'm back. We're back with Courtney Clenney. Hi y'all. Hi y'all. This hearing is really as actually recent. Um, I think it was on Friday. Yeah. Hello. Hi 𝗍𝗵𝗶, hi Crease, hi Debbie, hi Evie. I saw Psycho Nerd. I saw Debbie. Adrian became a member in the last live. Thank you, Adrian. Drakey. I saw Belita pop in earlier. Hi Angie, love you too. Thank you for being here. Um, hey Shay, good to see you, love. Hope everyone who's in crazy weather. I think I know Shay said she was snowed in. So I hope all of you are all okay. It's just really cold here, but no rain or snow. So I don't know what that's like, but we're back with Courtney Clenney. She had a motions hearing on Friday. And basically, Courtney Clenney is going to trial in April, which we are going to cover. We're going to do full live streaming on that trial. I've been waiting forever. And we're going to watch this motion hearing, which is basically they argue about what to let in and as expert witness testimony. There's like I think they want to put some of the audio and video of them fighting. I think the defense is trying to get to not come into play, but some were denied, some were approved, and then they want to, let's see, defense and prosecution arguments were heard on pretrial issues, including objections over expert witness testimony. The judge denied the defense request to strike a prosecution expert witness, Dr. Michael Brannon, despite the defense arguing a personal conflict with their own expert. Several recordings the prosecution wanted to use were argued over. The judge agreed to suppress some recordings that the defense said were illegally made, while allowing others that were made when there was no reasonable expectation of privacy. So I have been following the Courtney Clenney case, and we do have a playlist if you want to get caught up. We're probably going to do like one final deep dive maybe in the next couple weeks before she goes to trial, for those that are not familiar with the case. But if you're not, she's the OnlyFans model who stabbed her boyfriend, 𝗠𝗲𝗹𝗆𝗆𝗆𝗆𝗆𝗍𝗍𝗍. And she ended up stabbing him. She's claiming self-defense, but there's like really bad, it was a very toxic relationship. It was very much Kenzie and Dom to an extent. It very much reminds me of that, like how they would talk to each other and scream with each other and get handsy with each other. And she claims self-defense. You let me know in the comments and in the chat if you do believe it is self-defense or if she's just batshit crazy and deserves to be in prison the rest of her life. There is also proof she had some violent, toxic tendencies with her ex-boyfriend prior to Christian. And she does allegedly suffer from, she was in rehab when she got arrested in Hawaii. And I guess there's some underlying mental health issues as well. So she didn't go to rehab though until this happened. So I don't know what to make of it with the whole rehab thing, but I don't know. Let me know what you think. Let's get to the hearing. Hello, Anton. And hello, Drakey, 20 inches or so. Oh, wow. Hey, Jimmy Soul. Yeah, I know. That's crazy. And hello, Anton. And hey, Nemo sign. Okay, let's play this. They do catch her making like funny faces and stuff at court, which I know has like been everywhere, but she has been in there for, I think, 3 years. Yeah.
All right, good morning. We are on the record now in the case of the state of Florida versus Courtney Clenney, case F22-14137. Would the parties please state your appearances for the record, starting with the state?
Good morning. Still?
She was arrested April 3rd, 2022. Oh, wait, just kidding. That's when it happened. She was arrested on August 10th, 2022. Oh, so she's going on 4 years in August.
On behalf of the state.
Good morning. And on behalf of Ms. Clenney, who is present.
Good morning, Your Honor. Sabrina Puglisi and Ken on my behalf.
Excellent. Give me one moment. I am going to get my notes in order. All right. So
Look at how different she looks too. I know obviously she's been in jail for almost 4 years, but like, wow.
today we are here for a couple of purposes. First and foremost, I know that there are some witnesses on Zoom for the defense motion to exclude. And who will be calling the witnesses?
Judge, I'll start with calling Dr. Lenore Walker,
Okay.
and she is present on Zoom.
All right, Dr. Walker. And Mr. Abraham, is there anything preliminarily before we begin the testimony?
Yes, Judge, I believe based off the stipulation, there will be recordings that set for the hearing. I apologize. So that's going to be the next hearing. I can do it at a turn, Judge, so no, there's nothing right now.
Okay, very good. Dr. Walker? She might have stepped away from her computer.
I just ask her to put her camera on. Let me just
Yeah.
Wow.
Oh, my camera is disabled by the host. I do see.
Yeah. That actually, we have to do that, otherwise we'd never get through a regular court session. Janet, can you please allow Dr. Walker to come on camera and unmute? All right, tell her to give it another try. All right, very good. Good morning.
Oh, there she is. Okay, perfect.
All right, Dr. Walker, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, very good. And Ms. Puglisi, you may proceed.
Thank you. And, Judge,
Wow.
before I begin, there's an issue about confidentiality.
I mean, she looks good. Just the blonde hair, the no filler, the lips are gone.
And a prior settlement that they had. In order to try to streamline this, I believe that both the doctors are willing to waive any confidentiality. It does not, as I explained to Dr. Walker, change the terms of any settlement and her understanding of it. It just means it allows us to be able to address the matter. Dr. Walker, do you agree that you would waive confidentiality?
Dr. Walker is, I believe, a psychologist who's going to be like, she's obviously a witness
Any kind of confidentiality
or an expert witness. Yeah.
clause that you have?
Yes, I do.
Okay, thank you. And
Whatever you
Judge,
call it.
I think we're all familiar with Dr. Walker's kind of her expertise, so I wasn't really gonna go into, her whole
Do you
background.
stipulate, Ms.
Yes,
Rapp?
Judge.
Okay, excellent. So Dr. Walker will be allowed to give opinion testimony.
Okay, Dr. Walker, and, the only thing I will ask is, I know you've been previously, been found to be an expert, but can you tell us again what field of expertise?
Yes, I'm a clinical and forensic psychologist with an expertise in trauma, especially interpersonal trauma such as sexual assault, domestic violence, and other forms of interpersonal trauma.
Okay, perfect, and we're gonna focus for right
She's awfully close to him.
now, we're really here for a specific purpose. So I'm gonna draw your attention to a prior civil lawsuit that took place in Broward County in 2004, and that was with yourself and Dr. Michael Brannon. Are you familiar with that?
Yes, I am.
And what is your understanding of what that lawsuit was about?
Dr. Brandon and his colleague, Dr. Sherry Carter, filed a defamation lawsuit against me for what they claimed was when I was teaching. I was a professor at that time at Nova Southeastern University, and used some clips from the news cast for testimony of different psychologists, because I was teaching forensic psychologists how to testify in court, and they claimed that I evaded by using, he said that I evaded him by using those clips in my class teaching.
Okay, perfect. And are you familiar with the amended complaint in the case that was filed?
Yes, I am.
Okay, and did you? Judgment, stipulation of the parties.
Thank you to you know who you are who sent me the Cash App. I appreciate you. I don't want to just be disrespectful and say any names, but thank you, thank you, thank you. I appreciate you very much.
And for A1 for identification into evidence.
All right, it will be admitted.
Defense Exhibit A1 is nothing, Defense Exhibit A is nothing.
Was the case ultimately dismissed with prejudice?
Wait, okay, so before we start, tell me, do you guys think it was self-defense? Do you think she's done enough time? She should be out? What do you think? Or lock her up for the rest of her life? I don't think she's gonna well, I don't know, to be honest. Kenzie got 15 to life, possibly. Well, 15 to life, but with the possibility of parole. Jamie got what was it, 25? No chance of parole, right? And then we have, I do not. Wait, you do not what? Oh, you think she did it intentionally?
Yes,
Okay, and was there a release sign to your understanding?
by each of us, each of the parties, yes.
And what was your
Yes,
understanding of any kind, if there was a settlement agreement, what was your understanding of it?
I had also filed a countersuit against them, and so all three of us agreed that we would not speak about one another, especially any kind of negative comments about each other.
Okay, so no negative comments against each other. Do you know if this agreement that you're referring to, was that ever memorialized in writing?
They are very different crimes, but she stabbed him, not hit him with the car, not with the car. Yeah, you're right. There is also, I don't think there's very little proof too. I think maybe there's one witness that says that Christian 𝗶𝗆𝗆𝗆 was like somewhat violent, but that's about it. So there's no like videos. You guys have seen the videos of her going crazy. We're gonna watch one of them because it's one of the exhibits in this hearing that comes up. So we're gonna watch it, but there's a couple of videos where she's just out of control, like hitting him and calling him racial slurs. It's wild. I think she's guilty. I do think she lost her mind, but I still think that's not a good excuse for murdering someone. Patty says, I think she would do it again. Yeah, on purpose, blind rage, but she did do it. I don't believe it was self-defense for a second. That spoiled little psycho brat needed to go away for a long time. Okay. In the elevator, yeah, the one on the phone, or where she's like, look for my phone. That's the one that we're gonna hear today because she's like beating him. Because it comes up, I think, in this hearing. So I even if it doesn't, we're still gonna watch it.
I think it was. I remember seeing some papers, but it could have just been my attorney who gave me the actual terms of it. But I saw it, remember seeing it, but this is 20 years ago, and I can't find it.
So you have tried to report it, you can't locate it?
That's correct.
So with your understanding of the fact that you can't have personal attacks against each other. What did that mean to you as far as handling cases with Dr. Brandon on the other side?
Well, in order to be a medical psychologist, you have to have the testing and interview evaluation that you would do, that the person would do. So I would have to hand over my testing and my evaluation, and then he would have the right to criticize it. And if he said anything bad or negative about my methodology, that would be violating the agreement. The same thing for me, I would be on the other side of the case for him, and I would not have that opportunity or the right. Said that's the first most important thing. The second is that it's not ethical to take on a case where you may have a bias, any appearance of bias. That's in the ethical principles of psychological.
We have to think and she has had the same defense team for the whole time, but also she did get denied bond like I think 3 times. So
Practice.
we're staying in there.
For forensic practice. So it would be wrong to take on any case that you're on the opposite side of.
And so let's break that down just a bit. When you say if he critiques your personal methodology, what about that makes you believe that that's personal attack on you? Or vice versa?
Well, it's a personal attack on my professional methodology on how I conducted an evaluation, which is perfectly appropriate in a case, but not against the person. And given the fact that he's already, we've already.
What's so funny, Courtney? Let me go back. What's his name? One of them is Prieto, right? Puglisi? Yeah. Wait, no, am I thinking somebody else? I swore that was them. Why is it saying something else? I'm pretty sure it is. Why isn't that saying it online? Yeah, Frank Prieto.
It's a personal attack on my professional methodology on how I conducted an evaluation, which is perfectly appropriate in a case, but not against the person. And given the fact that he's already, we've already had this kind of contentious history together, it just would not.
What's like funny? So this is a case of a woman abusing a man. I said it yesterday, how good men end up with bad women and good women end up, yeah. Yeah, they were together for a while. It was really toxic. She's an OF model. He worked for her. They ended up doing content together. There's, videos of her acting crazy, had a drinking problem. She had stabbed him once. He had to go to the hospital. He was fine. Was it in the leg? I can't remember where she stabbed him the first time. So it had already happened before, but he survived. And then they ended up getting back together. And then one night they're living in this really like luxurious condo or whatever in Florida. And she ends up stabbing him like in the heart, basically in the chest. And he basically dies on the scene, and she claims self-defense. And then her defense team has like brought in like a pig one time because she claims she threw the knife across the room, but the extent to how deep it was, science experts are like, no, that's not possible. Like she had to be in close range. So pretty much that sums up.
Be appropriate, nor would it be fair to the client that would get us more involved with who we were and what we were dealing with rather than what the client's needs were.
And you secondly mentioned professional ethics. Were you referring to the ethics
Watch that,
of
Harlot.
psychologists and the specialty guidelines for forensic psychology, the standards there?
Yes, I was.
Okay, and specifically, standard 3.06 and guideline 1.03, can you explain exactly what those standards say?
Yes, standard 3.06 is a title conflict of interest. And it states that psychologists refrain from taking on a professional role when personal, scientific, professional, legal, financial, or other interests or relationships could reasonably expect to, one, impair their objectivity, competence, or effectiveness in performing their functions as psychologists, or two.
So you guys are not confused here. Basically, what's going on is this witness, Dr. Walker, she's a domestic violence witness, and the defense is objecting to their basically her being a witness because her and Dr. Michael Bannon, they had a professional dispute before, I believe, and it was a defamation. I believe she said defamation lawsuit, and Dr. Walker testified it would make her uncomfortable to remain involved with Bannon in the case. So she is an expert witness specialist in the domestic violence whose involvement was discussed, in pretrial motions. So that's what they're arguing, right, or debating here, whatever, discussing.
Person or organization with whom the professional relationship exists to harm or exploitation. The specialty guidelines, which are only guidelines but considered best practices, guideline 1.03, avoiding conflicts of interest. Forensic practitioners refrain from taking on a professional role when personal, scientific, professional, legal, financial, or other interests or relationships could reasonably be expected to impair their impartiality, competence, or effectiveness, or expose others with whom a professional relationship exists to harm.
And knowing these ethical obligations that you have and Dr. Brandon have you tried?
This whole smiling, she's really smiling a lot in this court hearing.
And knowing these ethical obligations that you have and Dr. Brandon have you tried over the last 20 years or so to not be on the same case as Dr. Brandon?
Yes, I have.
And did you provide me with an email that goes back as far as 2011 between yourself and Attorney for Regional Conflict Counsel, Kelly Peterson, explaining to her that you couldn't take a case if Dr. Brandon was on the other side?
Yes, I did.
Now, there have been some cases that you have been listed as a witness and Dr. Brandon's on the other side, so I want to ask you about those. The first one, well, let me ask you this. Have you ever, if Dr. Brandon was first listed, that's so much better, thank you. They just made you a big block, so now I can see you much better. If Dr. Brandon was ever listed as a witness first, have you ever accepted a case opposite him?
No, I have not.
Now,
That's my own.
Now, in a situation of State of Florida versus Lewis Late, you were listed as a psychologist on that case by the defense?
Yes, I was.
Okay, and later, Dr. Brandon was listed by the state, is that correct?
That's correct.
Did you advise the defense attorney in the case of any conflict of interest that you believe existed?
I
And who was that attorney?
did. That was Jeffrey Wiener.
And at the end of the day, whose decision
Assuming it's her family, maybe her parents in the gallery.
is it whether to disqualify or move to disqualify an expert? Is it yours?
No, it's the attorney's, at that time, it was the attorney's, decision.
And so did you end up testifying and Dr. Brennan was also a witness in that case?
I did, that's how I understood that, how uncomfortable it was for me, given the agreement that we signed to be able to do that.
Can you explain more about what you mean by uncomfortable?
Well, I have to I have to pay attention to what my information is, for the client. I can't pay attention to myself and my feelings. And I was very uncomfortable, and that interfered with my ability to pay attention to what was happening, and making good decisions and responding to questions. I was afraid of being somehow violating, the agreement, which I didn't want to do.
And now there's another case of Satoya Johnson that you were listed as a witness in that case. That was a Broward County case.
Yes, that was many years later. Again, I was hired first, and I performed the evaluation. I think there may even have gotten depositions in that case. And then Dr. Brandon was hired by the state. And I did not want to turn over my documents, my evaluation documents to Dr. Brandon. And so I got his.
Now, the next and the last case that you have, besides this one, that you've been listed as a witness alongside with Dr. Brandon, secondly, is the 𝗠𝗲𝗹𝗆𝗆𝗆 case. That's a current case in this district here in Miami-Dade County.
That's correct.
Okay, and have you had to testify in that case as of yet?
No, I got completed the evaluation, I have submitted a report, and the attorney asked me to turn over my rotated documents behind the evaluation, and I again said no. And the attorney, I think it happened almost the same time as it happened in this particular case. And so the attorney said that he's just to wait and see what happens with this case.
Okay, but you did advise him of the conflict.
Definitely.
Dr. Walker, what are your concerns of Dr. Brandon remaining on this case here?
Oh, wow.
Dr. Brennan, and I were actually at a meeting, maybe 2 years ago.
Wow.
I was the presenter. I was extremely uncomfortable, in the audience. I don't know exactly why, but I think just emotionally, it is very upsetting for me. I
Whoa.
have never been involved in that kind of defamation lawsuit before, or that kind of hostility that I have. And so, I feel that this has been so contentious, it's been lasting for so many years, and that it's not fair to myself as a professional, nor to my work for the client, to have to deal with him and my uncomfortable feelings with him. I need
Oh,
to
wow.
focus simply on my job as a forensic psychologist.
And you understand that as an expert witness, Dr. Brandon would have the right to be able to sit in on your testimony, just like you would have the right to sit in on testimony that he does, right?
Yes.
Okay.
Oh, wow.
I don't have anything further.
Cross-examination?
Yes, Judge. Good morning, Doctor.
Good morning.
So this lawsuit, this was 22 years ago, right?
Yes.
And in that, the resolution of that lawsuit, it resulted in both of you all settling, both the parties settling and the case being dismissed for prejudice.
Correct.
You've actually worked against Dr. Brandon now since that, and we at least have 3 different occasions concerning that.
Only one time. It was the light case, and that was way back, at least 20 years ago. I've never worked up in any other time.
So Cecilia Johnson is not another case?
It was a case that I got off of rather than, work and having to jeopardize what I got was jeopardize my objectivity for the client.
Right, but you made that decision. It didn't go before a court.
Well, the attorney and I made the decision.
Again, you made that decision.
Yes.
Now, with this agreement, and right now, as we sit here today, you've waived any sort of confidentiality, if there so exists one, right?
I'm sorry, I don't understand what you mean. There is an agreement. I have a copy of it. And I did agree to waive the confidentiality that states in that agreement for today.
For today or in its entirety for this case?
I believe it's for today.
So you have an issue, and again, you haven't presented this confidentiality agreement for the future.
Why is she smiling?
Or, I guess, some filing showing that this is a confidential settlement.
I don't understand what you mean. It's been already filed, and it's already, I have a copy of it. And I believe even it states,
So does that objection say to move
Sucks too, because she was making money on OS.
in 1B, 1D?
Around the time I think this happened.
1C.
All right, they'll be admitted.
then,
One moment, Doctor.
Just for the record, Space Exhibit 1B was space 1, 1C space 2, 1D space 3.
And can you pass those back to me?
Yes, sir, I'll pass it to you.
Okay. Mr. Abiac, do you need those back? Or can I retain them? Okay. All right, you can proceed.
So, Dr. Walker. I'm sorry, are you alone?
yes,
Are you alone in your office?
my husband just walked into the room and was making noise, so I was trying to ask him to, not in my office, but I told him.
Okay. So concerning, this sort of court order, and I just want to make sure, because you keep looking off to the side, that I have your attention. Are you good? You're on?
Yes, I'm alone. I was looking at the document. I was going to read you the statement from the document when you stopped me.
Okay. Concerning
Wow.
this document and these documents concerning this case, there is no filing of this court, of that court, the judge that presided over that has the terms confidential in it, that's filed and a part of the document.
So the court from the original case, the document that I have, was filed by the court. I have it in my hands. And number 5 is, the addendum that, sentence says, obligations imposed by this paragraph, which are the confidentiality, are ongoing and shall survive the court for the purpose of enforcement. And this is the,
So, doctor, and I think,
and this was,
I think it's the Kimmy, I think it's like the court audio. I don't even think it's me or Law and Crime. It sounds like an echoey kind of.
this was by this one.
so doctor, and just for the record, we're going to agree to stipulate to another document coming in, I believe, you know what's marked?
It's A2.
A2 coming as defense exhibit.
Let Darlene be. Let's not overstep our expertise. Yeah, the clerk knows how to,
Stepping out of my.
Yeah, exactly.
Stepping out of my.
A grade there. Okay, you said B, right, Darlene?
It's big, Judge.
Yes, ma'am, thank you. Go ahead, Mr. Abner.
So Dr. Walker, concerning this document that you're referring to, the court now has it, can you indicate to the court, to this court, where that is signed by the judge that was over your case?
The last page.
The last page that has number 3 at the bottom. Just so that I'm talking about the same thing. Can you say,
Yes, I by Judge Robert Van Sanders.
can you say whether
And on, yeah, I may as well sit down and do it.
So Dr. Walker, I'm going to ask you, where is this signed by the other parties? Dr. Brandon or Dr. Carter? Or their attorneys?
It is, if you look at the last pages, the first page of mine says from my attorney that says that they will have individual signatures of each, for each party instead of circulating one copy.
Would it surprise you, Dr. Walker, that, and these aren't numbered, but page 1, page 2, page 3, page 4, page 5, and page 6 were actually not filed with the court in that case, and were not agreed to by Dr. Brandon or Dr. Carter?
Oh, wow.
That's not what I was told. I was talking about 20 years ago. And I do have signature pages
20 years ago.
that are similar to the ones that I have.
Correct, and that is the final orders, but that does not include that confidentiality statement. And actually, are you aware that the clerk of court combed through this file, and the first 6 pages of this document has never been filed nor agreed to by Dr. Brandon or Dr. Walker?
That's not my understanding.
Oh, wow.
I understand, but I guess my question to you is, are you aware that the clerk of court did a search? This court issued an order for any confidential documents to be able to be turned over, and there are none.
Well, I have the document. I think the judge now has it, maybe you have a copy of it. And you have a letter from my attorney saying that it was turned over, so I cannot explain it. And I have followed it, and Dr. Brandon has followed it up until just this point. And so why would he be following it for 20 years if that wasn't his understanding? Doesn't make
Oh,
sense.
wow.
Doctor, when it comes to this confidentiality, are you willing to waive any confidentiality going forward in this case, if it so exists?
No, I'm not looking to make confidentiality. I'm sorry. I don't want to get into the weeds of what happened at that time. I don't think Dr. Ryan does it either.
Well, Doctor, you speak for yourself only, and not other doctors, but my question to you is,
Wow.
now that knowing that there is no court order making this a confidential case, are you unwilling to waive confidentiality?
Object, because I think this is beyond her knowledge and expertise. She's asking questions about the law, and that's beyond her knowledge.
It's overruled. Repeat the question, please.
Doctor, knowing that now that there is no confidentiality order by the court that handled your case, are you saying that you are unwilling to personally waive that conflict?
That's correct. My understanding, it is possible that the court does not have the document. That doesn't mean it wasn't filed. It simply means it's not 22 years later or 20 years later, we don't have it.
Well, doctor, and that's,
So I'm not willing to accept that it's not, that I'm not bound by it.
despite this agreement that you had to settle and go your separate ways, at least in concerning Lewis Light 2009, you did participate in that case.
Yes, I did.
Am I like thinking too much into it? Or are they like awfully close with each other? Like, geez, I'm going back.
I have the document, that doesn't mean it wasn't filed. It simply means it's not 22 years later or 20 years later, we don't have it.
Well, doctor, and that's,
so I'm not willing to accept that it's not, that I'm not bound by it.
despite this agreement that you had to settle and go your separate ways, at least in concerning Lewis Light 2009, you did participate in that case.
Yes, I did.
You chose to participate fully in that case and testify.
And it didn't go well, which is why I'm now insistent upon not doing it.
Question for you on a conceptual standpoint of cases that you are brought into on. Doctor, there's no doubt you are an expert for battered spouse syndrome, right?
Yes.
And for a defense attorney, that this defense is not something the state ever brings up, right?
No, that's not true. I testified to the state of limitation when they have raised it.
That's not my question to you, doctor. When it comes to an affirmative defense of battered spouse, you were always hired first.
Well, I can be hired also by the defense, by the state rather, because it's my understanding that the law allows the state to examine somebody who brings up, battered woman syndrome as a defense. And I have been hired by prosecutors, who have wanted me to look at the case and say whether they thought what my opinion was about how, if and how battered woman syndrome might impact the person's state of mind at whatever the act is or the event is that issue. And so that I would then be hired second, and I would not take such a case if Dr. Brad was the original or the first person who was hired.
Right, that would be your personal choice.
Well, it would be my ethical choice. I would believe that my interactions and with Dr. Brandon are such that I would not be able to be objective. And it's my goal to be an objective professional in these cases. And so I wouldn't want to do something that first of all would be unethical, second of all would possibly harm the client. That's not something I would
It's just an observation, MSM. Hey, Q, good to see you.
I've been doing this for many years, and I just wasn't doing it.
Doctor, concerning ethics, there's a board that monitors ethical actions of doctors, right?
Yes, I'm not sure I'd say monitor, but, you certainly could be reported to.
And you can report someone if you believe they are violating their ethical values, their ethical obligations.
I could.
There has never been a report from you concerning Dr. Brand.
Because we have not engaged like this before.
That's not true. You engaged in Lewis Light in 2009.
And as I explained to you, that was a case that, I did not realize, it was the first time that occurred, and I did not realize how it would impact me. And as soon as I did, I stopped doing it.
And Cecilia Johnson, 2018, when you decided to get off of that case, you did not refer Dr. Brand to this ethical board.
No, it is another ethical, issue that, I did not go further. If I would have gone further and stayed on the case, then I might have had the opportunity after the case is over. But there's such a thing as witness tampering, and I would not report somebody who's a witness or scheduled to be a witness on a case, until after the case is done.
Doctor, 2009 was a long time ago, right?
Yes,
2018, now it's kind of a long time ago, right?
yes,
Both Lewis Light and Cecilia Johnson's cases are over with, and you have not reported Dr. Brand to any sort of board.
I've had no experience with this that would make me report him. He chose to stay on the case, I chose not to stay on the Cecilia, well, I don't even know if he was on the Cecilia Johnson case. I only knew that if I was not going to send my, documents to him, and the attorney and I agreed, then I would get off the case.
𝗠𝗲𝗹𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗆𝗔I didn't know, as soon as I knew it was I informed the attorney, they did not, say anything to me until, I then knew it, and at this point, we knew that, this, case was coming up as well, and that we were gonna handle it in front of the judge. So that was no reason for me to report it.
Old days. I'm surprised you haven't watched this playlist. I do have a playlist with all the body cam and everything from this case. I said at the beginning we'll probably do like a big deep recap deep dive when trial starts in April. So we'll definitely do something like that prior to, so we're refreshed.
Concerning your notes and Cecilia Johnson, that case, you decided personally you did not want to turn over your notes.
Yes,
And it's your testimony you never turned over your notes.
well, I think I did not have a deposition, but I did not turn over, anything to, that I were to Dr. Brandon.
Is it your,
Possible that it's possible that the defense attorney may have, turned over what she had to do, but, I did not.
is it your testimony that Dr. Brandon was not provided your notes in that case?
It's my testimony that I did not provide my notes to Dr. Brandon.
That wouldn't have stopped the defense attorney from fulfilling that obligation, though.
Yeah, the last hearing, Kimmy, that we watched, it was about one of the security people or hotel employees. They had it on their phone, so they were trying to get that tossed out, and it didn't go through. I don't think. No, it didn't. I think they're allowing it.
Objection falls.
I don't know, I'm saying,
Dr. Walker, you don't need to answer that question. Go ahead, Mr. Abraham.
Concerning the understanding of the agreement with the judge, your understanding is that you're not to make any negative comments about each other, right?
Correct.
And you, without any explanation or understanding from the court, take that to also mean that you cannot comment on someone's professional work.
Of course, this is all about our professional work, not about personal comments. I mean, he was upset with me for, what he claimed was using his testimony, as examples in my class.
And there is no court order that prohibits you or him from testifying as to each other's work or to comment on that work.
I don't believe there's a specific court order about that, but there's no way I could comment on his evaluation, without commenting, on if I saw something that was not appropriate or not what I think would be appropriate, methodology, then I would have to say something that would be negative or bad.
Doctor, if he waives any liability for you commenting on his work, are you saying to this court here that you will not waive the same?
Correct.
Does that answer the questions?
Redirect?
Thank you. If there is no court order, do you still believe there is a settlement agreement in the case?
Yes.
Are you an attorney?
I'm sorry?
Are you an attorney, Dr. Walker?
No.
Did you draft any of the legal documents in
Oh, wow.
that civil case?
I did not.
Did you personally communicate with Dr. Brandon's attorneys in that case?
I did not.
Did you file any documents with the court in that case?
My attorney said on my behalf.
Did you personally though?
No, I did not.
Are you,
I was represented by two sets of attorneys because Dr. Brandon also sued Northwest Southeastern University in that lawsuit. And so, I think the attorney Cantor was also involved initially, and then I had a second attorney for my malpractice, insurance. So I had two different attorneys' office. I didn't keep track of what they were doing.
are you aware that it's not uncommon for settlement agreements to exist but not be filed
Objection, that's
publicly with the
speculation.
court?
Sustained.
Do you have any,
No,
it's okay.
One
I'm
moment,
gonna ask
Dr.
you
Walker,
one
she's
question.
gonna ask the next question. Go ahead.
okay.
Are you familiar with the law on settlement agreements and whether they need to be filed or not?
I do not. And I have no familiarity with it. It's the only case I've ever been involved in,
And
that would,
did you sign a confidentiality agreement in this case?
I did,
Do you believe it still exists?
I do.
And do you believe it would be unethical and cause harm to the client if Dr. Brandon were to remain on this case as a witness?
I do.
I have nothing further.
All right, thank you, Dr. Walker. You're excused. Have a nice day.
Wow.
All right, we're gonna move on to Dr. Brandon. Hi, Dr. Brandon, how are you? Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, very good. Mr. Abraham?
Yes, Judge. Good morning, Dr. Brandon.
Good morning.
All right, and is the defense willing to stipulate as to his expertise as well?
Yes.
All right, very good. Dr. Brandon will be allowed to give expert opinion testimony.
So, Dr. Brandon, can you shed some light into this lawsuit between yourself and Dr. Walker to the court?
Sure, it's pretty simple. There were several students who were from Nova Southeastern University who were doing more practical work in my office and some day work. And several of them had reported to myself and my partner, Dr. Sherry McCarter, that Dr. Walker was making negative comments about us routinely in the classroom, specifically about us being unethical and that they should stay away from us and not have any sort of experience with us or any sort of contact with us. So it had nothing to do with playing videos. The videos they had done or not, I don't quite remember, it was 20 years ago. But our concern was, Dr. Walker, if that was true, was what the students were saying, was making negative comments that we felt would affect us in terms of our careers at that time with future students and colleagues, as well as other people at Nova Southeastern University. So that was our concern, was just to get her to cease and desist if that was what was occurring.
And Doctor, concerning the resolution of that matter, could you explain, for one, was there an agreement to dismiss the case?
There was, yes.
Concerning that, did you sign an agreement in order to stipulate to that agreement that the case would be dismissed?
That would be discussed, yes.
Did you ever sign anything concerning confidentiality?
No.
Had you actually signed something like that, would you be willing to waive any sort of confidentiality in order to be a part of this case?
Yes, absolutely.
Oh, wow.
Concerning the court's
So it's Dr. Walker that has the issue here.
order that is filed in part of this case, what was your understanding as to what you were prohibited to do?
Well, in some ways, similar to what Dr. Walker said, that we should stop saying personal things about each other, which was really the basis. This wasn't anything that happened in the case in the courtroom. It was just negative comments made in the classroom about us as told by several students. So my understanding, matter of fact, our attorneys, the separate attorneys, myself and Dr. Carter on this, basically told us the judge said we should stop saying bad things, negative personal things about each other. And the Dr. Walker had agreed to that, and that was part of the agreement. And I thought it was resolved. I thought it was completed that way. I haven't given it much thought since then. So if Dr. Walker agreed to that, whether she did it or not, she made that agreement, we made that agreement, I think it was negative comments, personal comments about her, which we hadn't done, but we were happy to make that agreement. I thought that was the resolution of it, and that issue was no longer at play.
When it comes to personal attacks versus critique of work, did you believe that this court order had any limitation as to you critiquing Dr. Walker's work?
Yes, we would have never agreed to that, especially then 22 years ago, next to us trying to get as much work as possible from the courts and attorneys, we would have never agreed to that. So if we felt there was some problem or difficult with us doing that, of course, we would do it. But we didn't see that there was any issue or problem once the matter was resolved.
And since the resolution of that matter, have you on multiple occasions actually been on the adverse side of Dr. Walker professionally?
Yes, sir, and as a matter of fact, the attorney, the defense attorney in the West Palm Beach case, the Clenney case, was Joel Bushorn. And he actually came up to me before the hearing. He was the attorney, the office side, I was testifying to the state. He said, I want to make sure it's not being personal that goes on here. You agree on saying personal about Dr. Walker? I said, of course not. I don't have any answers to it. Of course I wouldn't say anything personal. It's all about issues. And that's exactly how that trial went. There was no personal comments or commentary or facts. I don't feel that way. I certainly wouldn't very comfortable if I did. So the that trial went along without any difficult verification or any accusations or anything improper, personal, unethical, nothing.
Concerning the multiple cases that you have worked as an adverse expert against Dr. Walker, at any point in time as a result of your involvement in that case, have you ever been reported to any board of ethics?
No, I'm really quite surprised to hear some of the testimony today. I didn't know
Oh,
there was
wow.
a strong feeling still. We were in an adversarial process, and as part of that process, people bang heads sometimes. But I don't think those things tend to stay around, especially 20 years later.
concerning this case, are you in agreement that you will abide by the order of that court 22 years ago to not make any personal attacks about Dr. Walker and her work in this case?
Well, if it's professional work, professional disagreements, reasonable experts to disagree. I certainly think Dr. Walker can talk about why, and she disagrees with what I do, and vice versa, in a respectful, ethical manner, being the experts that we have.
What the heck?
Consistent for as long as we have.
It's the camera like in Courtney's crotch. That was random.
Why?
Maybe it was the handcuffs. I'm
And concerning this case, are you in agreement that you will abide by the order of that court 22 years ago to not make any personal attacks about Dr. Walker and her work in this case?
Well, if it's professional work, professional disagreements, reasonable experts to disagree. I certainly think Dr. Walker can talk about why.
Oh, yeah, it's
she
the
disagrees
handcuff.
with what I do, and vice versa, in a respectful, ethical manner, being the experts that we have and consistent for as long as we have been. I don't think that's personal, but I think it's about issues in the case. So we're both taking an objective approach to a case, we can disagree and put those matters before the jury, before the judge.
Does that have further questions?
Cross-examination.
Thank you. Dr. Brandon, are you familiar with the amended complaint that was filed in your case?
So we're going to use the court file, so we got a copy of it. I hired an attorney to get a copy of it for us. So where it's in the court file.
Okay, perfect. And that amended complaint, it was obviously not drafted by you, it was drafted by your attorney, Joseph Flip, is that right?
Sure, there's another, yes.
But you are familiar what is written in there, there's nothing that your attorney wrote that you disagree with, would you agree with that?
Correct.
And so in that agreement, in that complaint, one of the allegations is that Dr. Walker said that you would do anything to win a case, is that right?
So I don't remember that, that sounds familiar.
Okay, and now, that's not a personal attack, right? That attacks your reputation as to what you do for a living, right?
Objection, Judge, speculation. Order.
Overruled.
You can
So I think that is personal. So if you say that, you're referring to the person who's not operating in the way that he should be operating ethically in the case. So I think that is a personal one.
Okay, but it's more than just personal, right? It's also attacking your professionalism, correct?
Sure, my approach to a case, opposed to my methodology, what I did or didn't do, or the test I used or didn't use, that's a different kind of commentary. That's a personal commentary.
Right, so you would say, if Dr. Walker were to testify she thinks you're unethical, let's say, that would be a personal attack? She wouldn't be allowed to give her opinion as to that?
Well, unless you can establish it in terms of procedural errors or difficulties or point out bias. So if you do that professionally in terms of the work that you do, I don't think so, which is her pure opinion, that's one thing. But if she's able to outline facts and data and evidence, more that, sure, I think that's very.
Now, you allege that her statement
She does look really different with her dark hair. This is her natural hair.
exposed you to hatred, ridicule, contempt, and or tended to injure you in your business reputation or occupation. Is that right?
Yes.
That as a result of her actions, you suffered shame, humiliation, mental anguish, and hurt feelings, and that would be experienced in the future. Is that right?
It's not an issue for me anymore. We resolved it the way that things are resolved in the court, which is we each filed lawsuits about it. So that's the way things are settled. So it's my personal feelings. I have no animus towards Dr. Walker at all.
Thank you. That wasn't my question, though. My question was that you said as a result of her actions, you sustained injury to your reputation and or health, sustained shame, humiliation, mental anguish, and hurt feelings in the past and to be experienced in the future. Is that right?
So Judge, I'm going to object because he did answer it, and she's disagreeing with his explanation.
We'll see yes or no first and then.
That's what he did.
Okay, folks, remember that Amber, who can't take down everything everybody's saying at the same time. The objection is overruled. Go ahead and ask the question again.
Okay.
So I did feel that way then, based on what the students reported, I don't have those feelings now.
Okay. But you do agree that this civil case creates a conflict of interest inherently, right?
Objection, Judge, improper.
Sustained.
Oh, wow.
You have ethical considerations that you must abide by.
Yes,
There's ethical principles of psychologists and a code of conduct, is that right?
yes, ma'am, correct.
And basically it says that you're supposed to refrain from taking on a role when a personal or legal relationship could reasonably be expected to impair objectivity, is that right?
Yes, ma'am.
And I'm assuming your opinion is that it's couldn't reasonably be expected to have an impair objectivity, is that what you would say?
Yes, Liberty, there has been a lot of playing dirty in this case.
Yes, ma'am. I have no bias or feelings towards Dr. Walker in that way. I did then, and it was resolved in 2006.
Have you advised any prosecutors that you were involved in a civil case? Let's be specific to say in this case. Did you let the prosecutors know when they went to hire you that, and you learned Dr. Walker was on the other side, did you advise them that you had a civil litigation against her from years ago?
Yes. Yes.
Okay. And in the 𝗠𝗲𝗹𝗆𝗆𝗆 case, I think it might be the same prosecutor in that case, so did you inform Mr. 𝗝𝗆𝗆𝗆 about that conflict?
Yes.
Okay. Now, you had not personally evaluated Ms. Clenney in this case, is that right?
Yes, ma'am, that's correct.
You haven't reviewed any kind of testing data, underlying data for her evaluation?
Yes, ma'am, that's correct.
And so, your involvement in the case so far has been limited to just some conversations you had with the prosecution, is that fair to say?
No, ma'am, I produced documents.
Okay, can you say how many documents, or let's just cut to the chase and say about approximately how much time have you spent in your review of
She's only 29 or 30 right now, I believe.
this case so far?
Approximately 20 hours.
Yeah,
20 hours, then I would like to know what you.
it is in Florida. And after this, we're going to watch some of the videos that, the crazy abuse videos.
I don't have in front of me, I reviewed information that was sent from my state attorney's office to Lucas, so I don't
Can't
have those
wait.
documents. I can provide those, but I didn't come to this year and prepare to do that.
Can you at least name some of the documents that you reviewed?
Judge, I think his answer speaks for itself, and he doesn't know.
I mean, 20 hours is a long time.
It's sustained. Next question, please.
Have you, strike that. Your understanding of the agreement is that it has to do with personal things. Personal things, though, you would agree, you know, a personal attack could be about the way a person dresses. That's a personal attack. Would you agree with me on that?
Sure, absolutely.
Okay, but you would say also if I attack your reputation, your credibility, your methodology,
Not a question.
I will,
Oh, okay.
I will break it down.
Sustained.
If I were to attack your methodology, you think that's not a personal attack on you?
It's not, no, that's fair.
If I attack your credibility, that's not a personal attack?
Well, it's based on evidence, it's based on data.
Okay, so your answer is no?
Well, my evidence is no, it's based on data, it's not, it's just a personal data, and that's a personal attack.
Okay, can I go on?
Of course.
Oh, is this where she makes the faces?
Oh, here.
Got it.
Just a moment. Sure. All righty, redirect.
Yes, Dr. Brennan, only one quick question. Up to this point, we've reviewed everything that's been provided to you. And the only reason you haven't reviewed the testing materials or notes is because they have not been provided to you.
Yes, correct.
But I don't know.
All right, thank you, Dr. Brandon. Have a nice day. You're excused. All right, are you ready to proceed with the argument, Ms. 𝗶𝗶𝗍𝗍?
Yes, Your Honor.
Thank you. You may proceed.
I don't think it matters whether it's confidentiality or not, at the end of the day, it's what both parties, I think there is no dispute that both parties agree they were not allowed to say negative things about each other, right? That's what we can all agree on. And so the question really here is, what does that mean as far as personal attacks? Because the case that was filed against Dr. Duran clearly wasn't about, something she did to him when they were seen at the grocery store. It was an attack on his reputation, his credibility. And then you look to the ethical rules and, it's a reasonable objectivity. It's not what that person thinks, it's what's reasonable. Is it reasonable to think that he still, it doesn't matter if it's been 20 years or not, that he still has some kind of bias? And, putting aside the fact that, honestly, candidly, there's a lot for cross-examination here, right? Like, the defense could cross-examine Dr. Brandon on all these things he filed in his complaint and whatnot. But that's not really the point. The point is fairness of the trial to Courtney Clenney. And we don't believe that having this doctor testify.
I won't lie though, the ASA, the prosecuting office did mess up and the prosecutor had to step down. 𝗠𝗲𝗹𝗆𝗆𝗆𝗆𝗍𝗍𝗆𝗍𝗍𝗍𝗍 There's been a lot that's gone on in this case. If I've been keeping up, but I think she should have got out on bond maybe while she awaited trial, but now, obviously trial's right around the corner.
Because what's going to happen is it's going to become a sideshow in this case, right? These two doctors had a lawsuit 20 years ago. It's going to be a, he said, she said, back and forth about that. And what it does is it takes away from what really is important, which is the battered spouse defense, which is a valid defense, and that, we are entitled to present, and we want to make sure, so at the end of the day, 403 analysis shows, we want to make sure that Courtney gets a fair trial. Now, then the question is prejudice, because I know that the state has a right to have their expert of choice, just like we do, but you then have to balance that. And so in this case, okay, let's assume Dr. Brand has spent 20 hours. He hasn't evaluated Ms. Clenney, he hasn't reviewed the underlying data. At the end of the day, 20 hours is nothing in comparison to making sure that she is given a fair trial. There are plenty of other experts out there, and the state has the opportunity to be able to go and get another expert before this goes farther. Let me just make sure if I have any other notes there. I mean, I think what's important here is that we hired Dr. Walker first, and she clearly is uncomfortable. She says she believes it's unethical. She says that she would not be able, she does not feel that she'd be able to answer the questions properly without constantly thinking about whether there's an attack or not. And there's no question that she does agree that it doesn't matter if anything was filed. I mean, I think it's common knowledge that civil cases of grievance are entered into and not filed with the court. That happens all the time. They're done, confidentially, secretly. And again, so what the exact terms, we know that they both agree they can't make attacks against each other personally. In her mind, it's a fine line, right? Between what is personal and what is professional.
Mm-hmm.
And it's very hard to distinguish. And she, to sit there while she's testifying and think, oh, is this going to be a personal attack or a professional attack on what he's saying? And so I think for all those reasons, Judge, I think under
I'll give it to her defense team. They've been hella good throughout this whole thing. But also, remember, it's going to trial, so it only takes a little bit for someone to believe that it was self-defense.
the analysis, we would just ask the court to disqualify Judge Brand in this case and require the state to find an alternative expert.
Mr. Abraham?
Yes, so the defense brings up this idea that confidentiality doesn't matter. It matters a lot, because without there being a confidentiality agreement, there is no limitation, as they bring up in their motion, to cross-examine this witness to the full extent of this lawsuit. So again, a lot of the things the defense brings up is fodder for cross-examination. The issue here is that they're kind of conflating the fact that the expert feels uncomfortable being a part of the case, that there's nothing in this lawsuit that prohibits him from being on a case against her. If there was, it would be in one of these orders. It just isn't. When it comes to this constant overthinking, that's a personal issue. She's got to work through that. Dr. Brennan has clearly said that he's going to work within the lines, and if it's not based on data and evidence and facts, it's not part of this. Your Honor has done a fantastic job with this case of trying to streamline us to trial. For us to get another expert at this point would delay this even further. The other part is Your Honor has the ability, once these witnesses are fully deposed, after they fully examine witnesses, to be able to fashion some form of limitation or not. If it's all fodder for cross-examination, and that's what it is. Your Honor has done a good job of managing this, and I believe you can do the same now. The issue that the defense has, this uncomfortability of this, is not supported by her own actions throughout time. She's had multiple cases in 2009, 2018, where the ability, if there is an ethical issue, which is what the defense is raising today, she could have sent him and his actions of staying and remaining on these cases to some sort of review board.
Dude, line crime.
We're just sort of walking through time where we're just raising our hands to the next defense attorney saying, I'm comfortable. And each of those defense attorneys are not raising conflicts because one doesn't exist. And that's why we're here, Judge. At this point, the defense has not shown that they're entitled to exclusion. They can't show that this court can't monitor this situation. They talk about this becoming a sideshow. It easily should not be a sideshow and be limited to not be a sideshow, because this is, and battered spouse is a case of facts and evidence and support. Defense brings up in this my last point that they hired their expert first. In reality of this, the state is not raising defendants' defenses or potential defenses for them. So in every case that there is a murder, what defense is asking is that we hire Dr. Brand and other doctors alike to completely negate this first to be the author of hiring. And that's just not possible. It's not feasible to taxpayers to have to front those bills, and it's not how this all works. It's just, at the end of the day, this first come, first served is not how this all works. We're able and entitled to be able to hire an expert that we believe can adequately and professionally handle this case. There's no issues at this time to warrant exclusion of Dr. Bryant.
Mr. Lepsi?
Judge, I would only just respond to direction by Dr. Walker to move forward in these 3 cases. Well, we know that he testified and she testified in the case in Palm Beach, Lake's case, and as a result of that, she understood what it was like. She felt that it was very uncomfortable and she was hampered, and as a result, she has made efforts to avoid that. Satoya Johnson, as soon as she saw that he was on, she withdrew. There is no need to direct to the ethics board because she's no longer part of that case. As far as the 𝗠𝗲𝗹𝗆𝗆 case, it's still pending. She hasn't testified and he hasn't testified, so there's no reason to send that to an ethics board. And similar to this, I guess we'll wait to see, what happens, but those are not the times to do that. So I don't think that whether she directed him to ethics board is really the relevant issue. It's more about whether Courtney Clenney can get a fair trial if Dr. Brandon is allowed to be an expert.
All right, thank you.
Oof. Anything that could go wrong with the freaking getting ready for trial, I think this case has had it. Her parents were wrongfully arrested. Well, they dropped the case. ASA stepped down. Footage has been questioned numerous times. 3 bonds. I mean, it's been a crazy, crazy case. Wow. I can't wait for trial. There's differing opinions in the chat, and that's exactly what's going to happen when this goes to trial. It's going to be crazy.
All right, at this time, based on the testimony and the arguments of the attorneys, the defendant's motion to strike state's expert witness Michael Brannon is respectfully denied. The court finds that the requirement for disqualification must have a showing of prejudice or compromise to the judicial process. The court finds that does not exist in this case, and any issues of cross-examination will be appropriately limited by this court according to the rules of evidence. And now we're going to turn our attention to the amended motion to suppress illegal recordings pursuant to Florida Statute 934.03 and 934.06. Is the state ready to proceed?
We are, Judge.
Okay, defense, are you ready?
Yes, sir.
Okay, very good. You may begin.
And briefly, Judge, before we begin, the state is moving in without objection 1A, which is a copy of the recordings that we are not stipulating to, and I'm going to announce these to the court which ones we are already stipulating for exclusion.
Okay, give me one quick moment here. I'm just reviewing my notes so that I can match up with what you're going to tell me next. Okay.
We can watch this now, but like when we watch those videos, those videos are actually disturbing.
So go ahead.
So from our motion, Judge, our response, we numbered them. And I'll read both our numbering and then actual what the file names. We're stipulating to exclusion on 1 through 6, 10 through 13, and number 17. Number 1 in our motion is ING_3758. 2 is ING_3772. 3 is ING_3775, 3776, and 3777, and 3778. That's 1 through 6. And then 10 through 13 is 3808, 3889, 3898, and 3917. And number 17 is 4003.
Can you go back? It was 3808, you said, and what was next?
3889, 3898, and 3917.
Got it, okay. Everyone's on the same page with that, Mr. Prieto? Yes?
Yes, Judge, just, in quarter where the state mentioned, it's number 17, 4003, that was also stipulated to?
Yeah, we're right about that.
Yeah.
Very correct, Judge, yes.
Okay, and the USB that you have presented into evidence is the items you are not stipulating to their exclusion.
Correct, it's 3782, 3794, 3797, 3997, 4001, 4002, 4005.
Okay. And for the record, the court has reviewed all of the items that are at issue, so however you wish to proceed in making arguments, you may. Yeah. Yes, ma'am, that's admitted. Is that marked as 1A for this?
1A will be space number 40.
Oh, it's a separate hearing.
Oh,
Right.
sorry. 1A will be space 1. This is a motion to, no,
This is the motion to suppress.
suppress.
Yeah.
Yes.
Okay.
Sorry.
Judge?
Yes.
So this next argument is going to be whether some of the recordings are illegal or not and whether they're going to allow them.
This is kind of the state and I were just kind of talking about this, with regard to the admission of the recordings that we just did. Based on the language of the statute, it puts us in a very difficult position. Because by the plain language of 93406, which is clear in its directive, it says no part of the contents and the regular quote in Florida statute 934.06, it talks about intercepting of oral communications. It says no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court. So by us putting this in, I don't want to waive anything here, is where I'm going.
Okay, you're not, and let me just cut to the chase on that. So this
Oh.
is for me to review the admissibility of it to become evidence. It's not evidence in the sense that this statute is discussing.
Right, it's just,
And I think the record can be very clear, you're not waiving that because you're moving to suppress those. So,
right, again, we can't put the toothpaste back in the tube because these recordings have been subject to chapter 119 requests from day one.
okay,
So they're already kind of in the atmosphere, but my thought process was, it's still gonna be out there.
unless we seal part of the record that if the court agrees with the defense argument, that,
Which is
let's say
what-
I agree with some and I don't agree with some, the ones
Correct.
that I agree with
Right.
shall be sealed by the clerk of courts.
Right, and that, I guess we can address that at the appropriate time.
Perfect,
Okay,
okay.
sorry, but I wanted to.
No, that's okay. I mean, listen, it's not a frivolous thing to say or think about, but I feel very strongly that, you know, in the court's gatekeeping function,
Correct.
that I'm not receiving this in evidence in the sense that it would be able to be presented to a jury or even determined by, if we would have a bench trial. This is an evidentiary admissibility issue at this point, so,
Sounds good.
okay. Mr. Abihoff, do you
Sounds
have
good.
any, yeah, no, I didn't know if you had anything else to say or,
I have no documents, I just am aware once, so, you know, the defense, keep track of where public records requests come from. We obviously do it with chapter 119.
yeah,
You know, what happens in court may not protect them absent other orders under, being.
That'll be a separate litigation, probably in civil court. Maybe, it could be.
There could be a gag order at some point, Judge, here, but at the same time, they've already been requested so many times.
Okay, Mr. Pietro, proceed.
Sure, Judge, you have our motion, the amended motion, the state's response, and the defense's reply, which I think both sides kind of lay out the applicable law, so we don't need to beat a dead horse with that. Your Honor, I'm sure has read everything. So we have here at issue the files that were already put on record by the government that they're not agreeing to, and 3782, 3794, 3797, 3997, 4001, 4002, 4005. And I will go through them in a group, but also individually. Again, the law, the directive by the legislature is very clear that these recordings, these types of recordings, as contemplated by the legislature, again, may not be received as evidence in a trial, hearing, or other proceeding, in or before any court, grand jury, etc. So it's very clear. And so when we look at the history of the statute itself, going back, it's been amended a few times in the last 20, 30 years. The McCabe case is one of those that I think is very instructive about how the courts, the appellate courts, perceive rulings by the trial courts and what their function is in interpreting statute applying to recordings. In the McCabe case, which was prior to the amendment allowing for recordings of victims of sexual molestation and sexual battery, the McCabe case was a case where the victim, a child victim, I believe she was a teenager at the time of the recordings, in her bedroom recorded her abuser, who made admissions as to committing a sexual battery upon her. Eventually, there was the arrest, and the court in McCabe, in the appellate case in McCabe, said the recording, as much as it pains them, that's not the appellate court's language, but they said the statute is very clear that so recording in a bedroom of where this would occur, and I can't remember the house or apartment, but this young lady who reported her abuser in her own room, or maybe it was in his room, but the court said you can't do that. The statute's clear.
Now, may I ask you for a second?
Yeah.
Is it McCabe?
I'm sorry,
or Dave?
McCabe.
Yeah.
I think I'm developing dyslexia as well. So this was the McDade case, and that.
It's in the amended motion.
So they're going to argue that videos made basically by Christian without Courtney knowing, they would be suppressed. And then the public videos like the balcony, elevator, outside when they're fighting, like those would be allowed, is basically what they're arguing here.
That was filed. The citation is going to be 154 Southern 3rd 292 Florida Supreme Court 2014.
Thank you.
Yes, go ahead, Mr.
Right, so in analyzing that, those recordings found to be inadmissible, despite what the court kind of evaluated expectation of privacy and whether society is prepared to recognize type of arguments. In that case, again, absent a directive by the legislature, the court said these recordings, no matter how altruistic the motives may have been by lower courts wanting to admit these things, the directive is clear, right? The trial courts can't legislate, or even the appellate court can't legislate from their respective benches. So what happened after McDade? The statute, and I don't know the year, but I know it was amended, and the legislature put in the exception. A victim of the sexual battery or sexual violence can, right, there's an exception for that. So how does that kind of reasoning apply to what we're arguing here? So let's just start by, and I was just mentioning, and it is in my reply. So the state, in their response, laid out a test. That test is not the law. I think it's instructive, but it is not the law. That comes from a federal court opinion that is quoting a dissent. I forget which justice it was, but that was not the majority opinion in that appellate case. But the state goes through their analysis, and I want to just present, Mr. Adams going to have a chance to present the state's position on this. So I'll state our position, their position, and rebut that. So let's, by starting with recording IMG 3782, that is, the state's argument is that there was no reasonable expectation of privacy. They base that argument upon the fact that this occurred in the 𝗠𝗲𝗹𝗆𝗵𝗶𝗽 lobby area, where you could, I believe the video, and just for the record, these are video files, but the video files contain extremely short cuts of actual video. The majority of these are audio, mostly audio. But in 3782, that lobby video, we see, or it appears very clear that Mr. 𝗠𝗲𝗹𝗆𝗆 had secreted his phone, walked away from Ms. Clenney, turns on his video device, which also captures audio, walks back over to a couch area, and has the phone positioned very, very close to Ms. Clenney. There's no indication that anybody was around them in earshot. You can hear some voices in the background, but again, we don't know how close these individuals were.
Wow.
And whether, and I would submit that the recording itself indicates it starts with Mr. 𝗠𝗲𝗹𝗆𝗆 lowering his voice, almost in a whisper, to Ms. Clenney. Ms. Clenney lowers her volume
Wow.
in that particular video, and it's clear that they're both trying to keep their voices down. Why? Because they don't want anybody to hear the argument, and that would indicate a clear expectation of privacy, both subjective and objective. So the state's argument that that video, there was no expectation of privacy because it's in a lobby, fails. Though it's hard to tell from that video, but it's a very large lobby area. It's
Yeah.
again, the audio portion of that, and actually the video portion, shows that the phone is exceptionally close to Ms. Clenney, and they both lowered their voices, indicating that they both had a mix it up. Ms. Clenney would have had an expectation of privacy, as Mr. 𝗠𝗲𝗹𝗆𝗆 is the only one that knows he's recording. He
Wow.
walked away to turn his phone on, which is very common for him to do.
So like, is Christian 𝗠𝗲𝗹𝗆𝗆 recording, for his own like purposes, to have proof or to get Courtney in trouble?
So, under analysis of the statute and case law, this large lobby area, although it is a common area in the building, the expectation of privacy is clear in that both Mr. 𝗠𝗲𝗹𝗆𝗆 and Ms. Clenney keep their voices down so as not to allow others to hear their conversation. So, under the statute, it would be admissible as she had a reasonable expectation of privacy in that conversation that she did not know was being recorded. So, second, file is IMG 3794. The state concurs that this recording was made in her private residence, but sets forth that and they get this from the dissenting opinion that they cited from the federal middle district that cited it, are not protected because of the nature, intent, manner, or purpose of the communication. So the recording itself, there's no, so this is how 𝗍𝗍𝗍𝗍 comes into play here when we're looking at what the state's arguing. There's no, because they repeat this on several of the audio video files, that, oh, this is evidence of some type of verbal abuse or physical abuse of domestic violence. Under the intersection of oral communications statute, there's no exception, right, for a domestic, assuming that the state is correct in their assertion that these recordings somehow capture a domestic abuse relationship. There is zero statutory framework allowing for a domestic violence exception like the legislature did in the sexual battery or molestation exception that they incorporated in the statute after 𝗍𝗍𝗍𝗍. So the state's argument fails. Again, the courts cannot read into the statute things that are not, the legislature has not put in there. So under a strict reading, which is what the court needs to do, of the 93406, the second recording, which is again 3794, there's, when your honors already looked at these, so it's abundantly clear in all of these, albeit one, the one in Colorado, we'll get to that these are all surreptitiously made. For all these recordings, the phone, you can see it's either in a pocket or in a hoodie, or it's being hidden when it's being turned on. There's no question.
She was secretly being recorded is what he's basically implying. I'm going to make a live for tomorrow so we can re-review like the body cam and stuff, because this case is really, really good.
The state even argues this, but there's no question that these recordings were made without Ms. Clenney's knowledge. So under the statute, the second recording, 37.
I think she has a chance.
This is exactly what the statute's meant.
Disregarding my personal opinion, she might have a chance. First Liberties is right. She might. Now, whether we believe she is crazy and doesn't deserve it, that's one thing. Whether we believe she's a battered female is another thing. But I think she might have a little bit of a chance
To not be admissible or even in any court hearings admitted into evidence. This is 3794 is an argument between two persons dating each other in a private home that is being secretly recorded by one of the other parties, which is illegal. It's a felony. So IMG 3797, the state's argument is that, hey, this one took place, and again, I don't think it's clear from the audio and the video. I think you hear in the background there's a noise that sounds like a slider.
Yeah, but right, they only need one person we can go by the evidence, which those videos we're going to watch in a second are brutal. But also, like, it only takes one person on the jury, right? Or no? Like, if half of them believe that she was self-defense, I mean, we never know. It'll be a good trial.
Or sliding glass door. I don't think it's clear, but for purposes of this argument, I think that the state's position that this occurred on the balcony is probably correct. But again, just because it took place on a private balcony, in a private apartment, in a private residential building that was quite honestly, it was a very exclusive type building.
Mr. Prieto, can I ask a factual question that I don't think maybe I should know this, but the way that the building is configured, some apartment buildings or hotels or whatever have a balcony where the next door neighbor, you could be like, hey, and you could see the person and they're very close to each other. What is the configuration of this building?
Judge, we went on inspections with this on this property in the civil proceedings. It is very private. You cannot see your neighbors
From the
from
balcony?
the balcony. It is walled off.
That's,
You'll have a chance to dispute it.
just for this clarification.
Okay.
Judge, so there's a barrier between every apartment.
Okay,
That barrier does not go all the way past the glass, and it does not go further than 4.5 to 5 feet. If someone's standing over 6 feet tall, their eyes are going to look onto it. When it comes to her angle, she's on the corner unit, so if we're facing south on the corner side, there is no other balcony on that side, on that part of the building.
Okay.
On the east side is where this could happen, where there could be new neighbors, but that's for that.
okay, go ahead.
Wow.
Yeah, so. I know I have floor plans somewhere. But again, you can't, if somebody's on a floor above or below, is there an opportunity for them to eavesdrop? Probably. But, again, additional facts if you have, about where or when this occurred, the private balcony area of the private residence in a private building, I believe, expectation of privacy on the part of Ms. Clenney. And again, this is an argument between two persons,
Yeah.
boyfriend and girlfriend, one of which, right, has, we don't know what happened before the recording started. All we know is that Mr. Owens.
I guess the question is, would we want to be recorded and it play a role in a trial if it's supposed to be private?
Zoe secreted his phone on his person, or in some of these held it, but did not display that it was being recorded to Ms. Clenney. Again, these are secret recordings made in an area, in a private residence, albeit a balcony. It appears to be a balcony, because you can hear some outside noise. But again, this is somewhere where a argument between a couple should be protected, and Ms. Clenney had a reasonable expectation of privacy. So the next one you kind of group together. This is IMG 3997, 4001, 4002, and 4005. Again, I don't believe it is disputed by the state that these were all recordings made in the apartment, Ms. Clenney's apartment, in her residence, and the only people present were Courtney and Mr. Rousseau. These are again arguments, and again, these are not anyone's best moments when they're having arguments with a significant other, which is exactly why these are the types of communications that should be protected. You know, when people are arguing, it is definitely not them in their best light, especially if there's alcohol or other substances involved. But the state, in arguing that 97, 3997, 4001, 4002, and 4005 come in, is because they're somehow the society is not in a position to recognize these conversations as private, which is nonsense. These are, again, secret recordings made by one party without the knowledge of the other. These are arguments made, or arguments taking place in a private apartment, in a private building, in a private setting. There is no such thing as a domestic, and the court likes to, the state wants to say these are the evidence that she's a primary abuser. But again, there's zero support, whether by case law or by statute or by analogy, that somehow these arguments are not subject to inadmissibility based on the statute. plain reading of the statute again, these are exactly the types of recordings that should not be made. So there's some case law that the state cited which
Courtney is at Miami-Dade County Jail, and she has been there since August of 2022.
talks about, oh, there was a recording in an office where the person being recorded was trying to extort, I forget the exact nature of their relationship, but in that case, right, the court looks at whether the criminal conduct that was being recorded was an extortion, and anyway, these were business settings in business offices. The other exceptions were, I think, like a checkout counter. Some of the case law talked about a checkout counter that somebody was overheard speaking. These were recordings that took place in the apartment between two individuals, one of which had no idea she was being recorded. So again, absent some legislative directive, the court has no other option but to rule that these recordings are not admissible in any case. Again, I know since this court, the court wasn't other proceedings that we've had, and I can't remember if at our relitigating on issue whether or not.
Come on, line crime.
I can proffer to the court, and Mr. Abbott can disagree with me if he'd like, but this is a very private rule. The only access, and this goes to the state saying in their response, hey, we have a recording of a security guard at the door of Ms. Clenney's residence that was able to hear.
What's up with long crimes footage on
They
this?
were saying, so clearly, if the security guard could hear them, and she's screaming, she's got no reasonable expectation of trial. Well, that's just nonsense. This building was very private. There was one key fob, well, not one key fob, but there was in order to get to Ms. Clenney's apartment, you have to have a key fob that works for that particular unit. Not that floor. As soon as you.
What do you guys think? Do you think it should be allowed or not? The footage that Courtney allegedly wasn't aware Christian was recording should be allowed.
Come out of that elevator, you are in Ms. Clenney's foyer. There's no entrance to a neighbor. When you're coming out of the elevator to the right, there was a door that led to the outside, several feet away, that led out to an area where I believe there was an emergency stairwell and an area where they could put refuse out to the right. But you have to go through another locked door of which no other residents have access to that door that goes into your foyer. To the left is the front door of the residence that could be locked. So you could basically get off the elevator and not have access to the apartment if that door was also locked. It was obvious that they left it open. But the only people that can access that floor are either if Ms. Clenney or Mr. Limselli gave somebody the fob to get into their apartment, or if it was a building staff member. And nobody, if they're having an argument, nobody's going to expect that either security or one of the other people is at their door. So these arguments that the statement, not the arguments between Ms. Clenney and her boyfriend, but the state's argument that, oh, just because the occasion was able to hear that through the door, eviscerates her expectation of privacy, that's just nonsense. This is a very private building. Again, private arguments taking place in a private apartment where Ms. Clenney had in her home a clear expectation.
Remember, it was like what was she paying? Like $10,000 a month or something for rent, or $20,000? It was a lot.
Of privacy. So this is not like, a ghetto apartment that I don't know that I live in where I can hear my neighbors through the paper door, through the paper walls. I've got 25 apartments per floor. You open up an elevator and, hey, good morning, how's everybody doing? No, this is a very private area, which is why a lot of people want to live there because of the privacy or privacy, as some would say from across the pond. So, again,
It's
all
10K
the
a
factors
month,
that
I
the
think.
state goes through, which they get from a dissenting opinion quoted by that federal case, those factors instructed for this court. However, the clear language of the statute controls. There's no judicially created exceptions to the statute, which is what the state is asking the Iran to do. Create some type of, as they term it, some primary domestic aggressor exception to the interception of her oral communications. Simply not supported by the law or the facts of this case. Thank you.
Thank you, Mr. Parikh. Mr. Adcock?
Thank you, Judge. So the defense talks about us citing to a number of factors in a dissenting opinion.
No, the 3 videos we're gonna watch, which are the most, I think, damning, is the elevator, the one where he's like on the bike, and then the one where she does racial slurs. I think they were all different times before, obviously before the crime, but not on the day of. No, I don't think so. The lobby was the day before, I believe.
That opinion cites to Brugman v. State 117, Southern 3rd, 39, 4th, 3rd, State 2013, which also cites to 𝗠𝗲𝗹𝗆𝗆𝗆, State 1272, 1985 for the Supreme Court. Case in Jatar v. 𝗠𝗲𝗹𝗆𝗆𝗆, what has the law? Why are those cases different than Dade? Residence of the offender. There is no screening, there is no actions that someone not within that residence would have been able to hear what was going on in that room. Being that it was his residence, he already has a subjective expectation of privacy for Miami-Dade. That's different than here. And going by each one, 3782, which is in that lobby, there is no expectation of privacy subjectively in the lobby, whether you're whispering or not. That is very, very specific and very different from Miami-Dade. And so 3782 is the easiest one to discuss here because it is in a public place where every case cites to, and you cannot have a subjective expectation, let alone an objective expectation. 3794 is now I'm not mixing them up, Judge, and I do apologize. So
It's in the residence, I believe.
3782. 3782 is in the lobby.
Lobby,
3794 is the one that's upstairs. The first one happens upstairs.
right.
So 3782 is the one I was just discussing.
Right.
The rest of them being 3794, 3797, 3997, 4001, 402, 4005. We can see it's in the apartment. There's a subjective expectation of privacy just being that it is her residence. But that's why the content and her actions have to be evaluated. The only ones out of all of those that she is not screaming is 3794. And that alone, the content and the actions of it, where the victim is asking for assistance and that he's bleeding from his head, where she responds, I know the fucking shit on your head is serious, I really want to fucking kill you. There is, that lacks the objective expectation of privacy. But that is the only recording that is close in time to the case. The only one where you don't
Remember, she had stabbed him before too.
have some person outside of their apartment that's going to be able to hear the actions. And that's why the state provided to this court that recording from security. Because you get an understanding of from outside that apartment what you can hear, let alone the noise complaints that are continuous from Ms. Clenney, where all of them are explained as we're hearing screaming coming from that apartment. And that's 3797, 3997, 4001, 4002, 4005. not only is the content be able to eliminate an objective or a objective and probably subjective expectation of privacy, but we get to this point where there is no, you're almost waiving your subjective expectation of privacy when you're screening to where anybody can hear it. And we had complaints from reports that were filed with this court, at least 2 floors down, that are saying, hey, this is what we're hearing.
Yeah.
Someone needs to go up there. The security guards are not just showing up to her door just because. They're going because they're receiving these complaints on numerous occasions.
Yeah, there was a lot of complaints about them fighting.
So when we talk about 𝗏𝗏𝗏 at best to the defense argument may apply to 3794. I would still say that it does not, but it doesn't come close. 3797, 3997, 4001, 4002, and 4005 because of her action specifically. She is specifically waiving that by letting the entire world know what's going on with their business. So that's the difference here. And it comes down to, I don't need to talk to the court much longer than this. The first one's and that's 3782, is in the lobby. No expectation of privacy, subjective or objective. The rest of them, there's a subjective expectation of privacy. She certainly waived it in 3797 and below. 3794 is up for debate, and that's really it.
What is your argument with reference to 3794?
The argument would be that when someone is coming to you to seek assistance, the fact that he's seeking help, asking for help, and her content is threatening in that way, it is to say that she is, it's the content. It's really just the content of it. That's the only argument I'm making.
Okay, Mr. Prieto?
Yeah, Judge, the state's talking about complaints made by neighbors saying they're screening work. That definitely occurred, right? There were complaints, noise complaints. But there was no noise complaint saying, hey, I hear Courtney Clenney saying blah, 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 X, Y, and Z.
Oof.
No, these are noise complaints saying, hey, I hear people arguing. That's very different from saying, I hear people arguing and hearing their exact words. Again, just raising your voice in a private apartment, in a private setting, during an argument with a significant other in that private residence does not waive, as the state would say, any reasonable expectation of privacy.
But if the court is looking at this from an objective perspective, and there are facts to suggest that people could, in fact, physically hear screaming out of this location, we've already determined, and everybody concedes there's a subjective expectation of privacy. If it is a fact that screaming can physically be heard, and if Ms. Clenney is screaming, that at that point, she is waiving that expectation of privacy objectively. That if I start screaming here in the courtroom, I can't expect that the words that I'm saying might not be heard out in the hallway, and especially if Judge 𝗏𝗏𝗏𝗏 comes out and says, I can hear everything you're saying in the courtroom. So talk to me about that piece.
Right, Judge, there's objectively, Ms. Clenney's not waiving anything by raising her voice. Again, this is within the 4 walls of her condominium where people complain of noise, but that doesn't mean that they can hear if the person speaking is waiving the content of their communication. The only thing that's making it through these walls of people that are complaining is a noise, a level of a decibel level of something, not the form and substance of the communication. And there's absolutely zero evidence, both in the recordings, that these particular recordings on these particular dates were overheard by anyone.
Wow.
By anyone. The recording that the state provided to the court of Miss, forget her name, the one of the security guards that had to go up to the door, place her phone up on the door, and she testified to this in civil deposition. But she had to go in there and basically put her ear up or the phone up to the door. So, and that is not a recording that the state is seeking to introduce, like all the ones that are listed here and subject to this hearing. There's absolutely no evidence before this court that anybody overheard these recordings that the state is seeking to introduce. There's no question that these were surreptitiously made, so that the state has to concede those. But as far as somebody raising their voice in an apartment to make the leap that eliminates any expectation objectively, any expectation of the contents of their communication is just not right. Just because you can hear somebody maybe screaming doesn't mean that you, as a person who may be raising your voice, is waiving the actual form and substance of that communication. There's no case law to support that. But again, there's absolutely nothing before the court that says anybody overheard these conversations. Was any way anybody did hear them or not? So, but the state's saying, well, because somebody overheard them once, that forever, by raising your voice, you have objectively waived any reasonable expectation of privacy. That's like saying, if the police execute, it's all wrong. Let me try to, probably shouldn't come up with things on the fly, but I'm going to say this. Well, actually, I think this is in the state's original response, saying, well, Ms. Clenney, if she knew that 𝗠𝗲𝗹𝗆𝗆 was recording him once, then she should expect that he's always recording him. And so she has no expectation of privacy. That's a nonsense argument. That's what the state's trying to argue. That's like saying, if the police come and serve a warrant at your house and the warrant was bad, well, you should know the cops could break your door down anytime after, so you have no expectation of privacy in your residence just because they did it before. So that argument that she knew 𝗠𝗲𝗹𝗆𝗆 would record her on occasion, that's not a waiver. Just like it's not a waiver to raise your voice. Again, specifically these recordings, there's absolutely zero evidence that anybody heard the communication, right? The statute is interception of an oral communication or wire communication. That doesn't say, well, hearing a noise is that communication. The communication is the words, the message of the words, not, oh, I heard somebody arguing. So there's no waiver, objective or waiver of subjective privacy in this case.
Mr. Abiel, you look like you may want to respond. Okay, go ahead.
First off, Judge, we are seeking to have that recorded by the security guard, and that's just not part of their motion. They're not seeking to exclude that. So yes, there are a number of recordings that we will seek to introduce. I'm not sure where McDade defense believes that this idea of what they're saying is the law is law. That's not what McDade says. McDade specifically lays out any oral communication uttered by a person exhibiting an expectation of privacy under the circumstances reasonably justifying such an expectation. That is the state of the law. It's not this, if you can make out every word that they're saying, that's, that's fine. That's not what the law is.
Wow.
So I get it. That's the best form for them to push forward their argument, but that's not the state of the law. And you can hear from that security guard that not only, this is from right there off the elevator, you can hear the exact parts of these conversations, but when you look at the complaints that are part of this file, and we provided the court with complaints from before, there are multiple complaints after this as well, and they go on until they actually get an eviction notice, and they're about to be evicted. So, there's a number of instances that puts her on notice that she is certainly screaming, and they've spoken to them on numerous occasions that everyone around their floor can hear this, to where there's we provide the court with 6 of them, up to a certain date, there's at least 10, if not more, complaints saying that we're hearing muffling, we're hearing a very specific argument where a woman is screaming. And that's the point of it. So my argument to the defense statements, they're misstating the law of McDade, they're misstating the law of this, what this court is required to follow. And because of her actions, of how she's addressing these conversations, she is waiving her objective expectation of privacy.
Mr. Pietro, did you have anything else to say?
Judge, I would just say the case law that both the state and defense have cited to, where the courts have found a waiver, objective or subjective, may be very fact specific. I would just encourage the court to read those again, because they are very specific of where they're finding either a waiver or some type of non-objective or a waiver of reasonable subjective expectation pricing. They're a lot different than here. These were arguments in the apartment. I don't want to beat that horse here, but again, raising your voice does not vitiate your expectation of privacy in your own home. And that's what we have here.
I'm just reviewing a few cases that I may have a question.
Oh, they zoomed in on her. The Courtney zoom. I like to be nosy and get a close up. I think Frank Prado is good looking. She definitely guilty. Really? We're going to play some of the videos where they're fighting in a minute. This is almost over. Dang, that judge really is like reviewing.
All right, based upon the court's review of the record, the pleadings that were filed by both sides, and I appreciate, I probably say this a lot to you all because of the level of preparation, and of course it's substantial, so I appreciate that very much. As to the defendant's amended motion to suppress illegal recordings pursuant to Florida Statute 934.03 and Florida Statute 934.06, the court rules as follows. The motion is respectfully denied as to 3782 which took place in the lobby, and 3793 that took place on the balcony, but granted as to 3794 and 3997 through
Wow.
2005. The court finds that that Ms. Clenney did not waive her expectation of privacy, as the communication that originates within the home, of course, is significant, and the actual interception of the communication occurs where it originates, not very.
Ooh, that's a win for her. Right? Some were denied and some were allowed. Did I understand that right? Wait, because they're allowing the balcony in the lobby, right? But they're not allowing the ones in the apartment?
Ultimately heard or recorded, as well as the fact that the record is devoid of any evidence to suggest that the actual communications at issue here were in fact overheard. Not to say that that would necessarily sway the argument or the ruling of the court, but I don't have that here. Now, the other motion, and I know we weren't planning to do this today, was the motion in limine on the CGI, but it sounded like there were some things that you were going to do.
Yeah.
Give the court, and where are we on that?
Yeah, Judge,
Yeah, so that's basically right. So it says most of the recordings made by the victim inside the couple's apartment without Clenney's knowledge would be suppressed, meaning they will not be allowed as evidence at the trial. However, the judge allowed recordings made in public areas, which was in the building lobby and in the balcony. The court found that there was no reasonable expectation of privacy in those, so they can be used at trial.
I think it's premature to really address that. There's, let me just say, there's, at this stage, some contractual issues that need to be worked out.
Okay.
Concerning that, perhaps.
Who the hell is that? Her girlfriend? Her friend? What? That's who she's been making faces to?
I don't need to necessarily be briefed entirely on that. I just wanted to know if that was something that you were ready to do
Well,
soon.
we wanted to talk to the court about it, and I haven't done this in so long, so I'm not sure it's for cost.
Okay.
We want to see if this client could be declared as indigent for cost. She doesn't have the funds to be able to proceed in the way we do. So I'm not sure how that occurs, if by motion, if we can have her fill out a financial affidavit, or if the court can ask her questions. I haven't done it in a while, so maybe.
Yeah.
I can correct.
I think it would be appropriate to file a motion along with the indigency affidavit, and then the court will rule accordingly. It's not really, I mean, I don't really think the state has much of a dog in that fight, that we would need to necessarily litigate it in open
Yeah,
court.
it's, to be fair, I think Jack needs to be noticed and copied.
Yeah.
Do we have any indigency forms here? that I can
Yes.
have her fill out now?
Darlene has that.
Just for clarification.
Yes.
I believe your honor said 3793 of the document. I believe that's 3797.
If I said, I apologize, my notes reflect 3797 was the balcony.
Right. You said
And that-
3793.
Thank you for clarifying. Okay, so
Sure.
3782 and 3797 are in. 3794 and 3997 through 4005 are out.
And just so the defense is in
Wow.
position, we understand the court's ruling as far as admissibility in 934, and 06. We will reserve our right to challenge under 403 or other grounds at a later time prior to trial. So
Understood.
the ones that you've said are not violated for 934.
Understood. I think just what's pending is the 404, which we have some depositions and things today before we file a response to it. And then that also, we're working on the reverse individual. And so there are a few things that we have to do. So I'm not sure if you want to set status before the trial or how we want to do.
Oh, yeah, for sure. 30 days? The trial is roughly in 60 days, or the sounding, that is, yeah, okay. So that puts us at 320 for the next status. I'm gonna put it as status for now.
Wait, where did she make those faces? Did I miss
If you
them?
want Ms. Clenney to be brought to court, just let us know the day before. Okay, anything else from the state?
No, Judge.
Defense?
No.
All right, thank you all for running that.
Thank you for your time.
Where did she make? There was a video of her making like some faces. Did I miss them? Or was that at the beginning? That's like what I was waiting for. Did I miss them? Wait for it. It's over. That's why I was like, did I miss them? Let me pull them up on another video. I think Vinny had them on. Yeah, I have 3 clips that I wanted to play regarding that. Did I miss it? Here, let me play this clip of Vinny. He had him on. And then I'll play the no, there was one where she like stuck her tongue out. I missed that.
Is gone. Like this is like reality is checking in. You're not living in a $12,000 a month apartment in the trendiest neighborhood in Miami. You're not flying off to Vail. You're not going skiing. You're not taking pictures.
So this was like her first, I think, hearing.
You're not interacting with thousands of men who want to see you naked. No, you're in handcuffs, you're in court, and you may spend decades behind bars. And you wear the orange suit. Okay. That was in 2022. Let me show you 3.5 years later as she gets, what's going on?
Yeah, this is what we missed in today's hearing.
On here? She's acclimated, I guess, to being behind bars and is now, you are getting ready for your murder trial. And she's kind of waiting for her case to be called and must have recognized someone in the gallery and is, blowing kisses, doing faces. It's almost like she's creating social media content from inside the courtroom. But really a strange twist today in a hearing that was very important involving some evidence that she wanted suppressed, not brought in. But I want to start first with what we're seeing inside the courtroom, because that's kind of the defendant we're going to see, not in the orange. She'll have regular clothes on during her trial. Let's bring back in our think tank, Josh.
I cannot wait for this trial. You guys better be ready for it. Okay, let's play the 911 call real quick. I don't want to play too much on here because I was thinking maybe we could just do a deep dive tomorrow. But let's play one of the fights. I won't play the 911. I'm going to play I think this is not going to be allowed, by the way. The one I'm about to play. Oh, wait. This one's bad too. I'm not going to play all of them. I'll make another live for that for tomorrow. We can review.
Talk to me! What is going on? Like, are you gonna get this mad at me when I'm apologizing to you? No, Christian. Like, you're thinking I'm doing it on purpose? Drop your high pitch. Okay, I'm not doing it on purpose. You touched the heart. You know damn well the right thing to do is to tell me. Yes, and I am so sorry. So shut up and let me f***ing slap you, dumbass. No, you're not gonna slap me. Give me my phone. You have your phone. I don't have it anymore. Find it and f***ing charge it. What? Find it and charge it! I mean, I'm sorry, Courtney. I don't care. Find it and charge it. Okay, just stop. Don't talk to me. Man. Yeah, man. Oh, man. Because I'm telling you I'm sorry. It's like, alright. Find my phone and charge it. I don't know where your phone is. Find it. Can you help me find it? I won't! So what? Find it! Why are you saying me, man? Not man, but yeah, man, yeah, man, yeah, man, oh, yeah, man, yeah, man, yeah, some old man, huh? Shut the up. I need to find it because I have to go meet her again. To go out? No. You said she invited you. Christian, just find my goddamn phone. I don't have your phone. Can you just find my phone? Stacey, can you just please shut up? Please. Shut up. You went to go f***ing talk to her without talking. I didn't go. Yes, you did. You always want to you f***ing asshole. Courtney, I was on. You literally told me about it. Now he's like, damn. What are you doing? I didn't go to talk to Aro. I was going on a bike ride. Like, what the? Get off of me! You gonna talk to Ari? Is this gonna make you act like this? You literally talked to her without telling me! Courtney, I was on a bike ride and she passed me and I said, hi, you and Courtney are having a live chat. My bad, I forgot to tell you that. That doesn't make you to act and call me a You're Yes, yes, thank you. Coming from Courtney, thank you. I want you to get away from me!
Ooh. That one's always rough to listen to. I'm going to play the elevator clip. And then we're going to end the live. I'll do a deep dive. We can do a deep dive. There's a whole playlist with the body cam. If you guys have not checked it out, you're missing out. I have a Courtney Clenney playlist. This one I found off of
video.
This is them fighting in an elevator.
That's them entering their apartment. You can see, you will draw your own conclusion, but it certainly appears that the defendant was aggressively attacking Christian.
That was his family standing right next to her. Yeah, the videos in the playlist have more audio and all that, but let's play the 911 call now. It's only 2 minutes. Why not? This is when she stabbed him.
Operator, don't please get us to your emergency. Please. 3101. It's 130, so 130. Ma'am, listen to me. You need to stop screaming on the line and give me the address. 3101.
You're gonna die. I can't feel my arm.
3101.
I can't feel my arm.
Ma'am, so my boyfriend is dying of a stab. Ma'am, what is the address? What's the address? What's the address, baby?
31.
3134 Northeast 7th Ave. Please, God, please, come see my husband. Ma'am, is this a house apartment or a business? I want you 7452582. Is this a house apartment or a business? Baby, I'm so sorry. Baby. Ma'am, can you hear me? If you have a stab wound to his shoulder, can you sit down? What do you mean he has a stab wound on his shoulder, ma'am? Yeah, he's bleeding from his shoulder. Rescue, this is PD position 2. The caller, ma'am, hold on one moment. The caller advised you address is 3131 Northeast 7th Avenue, 31 Northeast 7th Avenue. The phone number is verified. The caller advised that her boyfriend has a stab wound. Okay, is this a house apartment or a business? This is please God, please God. Please God, listen, ma'am. I'm sending help. I need you to tell me exactly what happened. I'm sending help. How old is he? Ma'am, how old is he? Is he awake? Hello?
Yeah. So if you're interested, there's a playlist, but like I said, I'll do a deep dive. We'll do one definitely before trial. So in the next few weeks or days. She's a loose cannon. It's a crazy case. And I have been waiting since it happened to watch this trial. I really have. I've kept up with it too on the documents and the hearings on my playlist. I think I didn't cover one of the recent documents like 2 weeks ago, which I don't think was too much, but I'll check the docket. I know there's some depositions going on before they have another pretrial hearing, which I believe is March 16th or the 20th. Don't knock me. I'll have to look at the docket. I'll pull it up tonight and look at it. And then trial in April. So we're almost there. Shout out to you guys for watching. We've been here for 2.5 hours. A lot of you say guilty. I know. But remember the jury. Yeah. I don't know what's going to happen. I don't. I'm really excited for this trial. Anyways, shout out to you guys for being here. No, we're not doing Elliot tonight. We're doing either Corey Richins tonight. I'm thinking of doing a trial replay for Corey Richins. So the woman they were showing, that was Christian's sister. Yes, it is, Abby. RIP to Christian 𝗶𝗶𝗆𝗆. Very sad how he died. But again, I'm eager to see what happens at this trial. She's going to get a self-defense instruction and be acquitted. A lot of people think so. We'll see. Oh man, I missed your life. Yes, Calissa, we're going to watch Corey Richins. So I hope none of you watched that today and you were here watching other stuff. We did Epstein and we did Courtney Clenney. And so now we're going to do a late night hangout and watch Corey Richins. I'm going to give it a day or two and see how I like the trial and if it's worth it for me to play and rewatch. Then I will. If not, then I won't. If the trial ever actually happens. Yeah, no, it's on the calendar. I believe. Let me pull up my calendar. I believe it starts the end of April. Yeah, so basically May. It's basically May. I think April 27th is Courtney Clenney trial. So we'll see what happens. But anyways, tap the like button on the way out. Where's Corey Richins' trial? Corey Richins' trial is out of Utah. I have never covered that case here, but I have been following it and I have been waiting for it. So yeah, I want to do replay. And then I wanted to fast forward through the breaks. So one day we will do Jody's trial. Thank you, Boomer. Old days, maybe tomorrow early. You got to make it though. You're the one always asking, but you never show up for Jody. I don't know if they were Mormons. I don't know if Corey Richins was Mormon. I don't think Corey was, but maybe Eric's family. I'll check. But hit the like button on the way out. Corey Richins live is already scheduled here, so you guys should be getting a notification. I'm gonna grab a drink, get ready to chill. We'll watch, see how we like it. I'll show up for Jody. Okay, you can show up for Jody. Yeah, tomorrow I'll probably do Jody early in the day if we do, and I want to finish the Elliott Manifesto tomorrow. But we also have a new case tomorrow, and we have not been following up on 𝗝�cypsy. So I need to get back to that too. We do true crime all day long, so we go through a lot of cases, old and new, throughout the day. I don't like to be stuck on just one thing. Eric's family is prominent. Oh, are they? Okay. Good to know. Thank you, Calissa Katz. All right. I think I'm gonna show up now. Okay, thank you. Please show up, DFJ. I appreciate it. All right, Corey Richins, get your workout. Get your workout earlier then. Or we can just, are you doing a live? Yes, I just said that. We're doing Corey Richins' trial. So it's scheduled. I will see you guys there in a little bit. Remember, there is a Courtney Clenney playlist for you to watch later if you're interested in that case, which we should, if we're going to watch it here together. You guys should be up to date with that. So definitely check out the playlist. All right, I'll see you guys shortly on the next live. Thank you for being here. Tap that like button on the way out. See ya.